My name is Charles Swanson. Today is October 4th, 2012, and I'm in Knoxville, Tennessee to interview Justice Penny White. This interview is taking place as a part of the Legal History Project of the Fellows of the Tennessee Bar Foundation in conjunction with the Tennessee Supreme Court Historical Society. Justice White, please tell us your full name and the date of your birth.
Full name?
Full
Penny
name.
Jo White, May 3rd, 1956.
Now, I've called you Justice White because that's who you really are. However, as you well know, I usually call you Penny, and throughout this interview, the likelihood is that I will call you Penny. I do not mean offense at that, but I just want you to be aware that I'm likely to do it.
Please do, but no Penny Joes.
I shall not do Penny Jo. Tell us about your maternal grandparents, Penny.
Well, my grandfather was a farmer in Southwest Virginia in a beautiful little town called Snowflake in Scott County. My grandmother...
What was his name?
His name was Charles H. Bush. My grandmother I barely knew. She was Ethel Bush, and she took care of the home place. My mother had two siblings, one of whom was Jo, that's my namesake, who died very, very young in life. And so my mother always said she was a farmer's daughter in every sense of the word. She did all the things that her brother couldn't because he was ill most of his life.
How about your father's parents?
My father's parents are from Greene County, Tennessee. Herman White was his dad, Herman Sevier White, also a farmer, but my dad's father also had a country store, the old-fashioned country store, mercantile store that he ran as well. And my dad's mom, Esther, was a, now that's completely bad, Etta was the name that we called her by, was a housewife also, in every sense of the word, a mother. My father is one of 12. So she, not all of whom survived childbirth, but she mothered all of those children and took care of her husband as well. For her pretty long life, she lived a pretty long life. My grandfather died young, however.
Now, your grandfather was Herman Sevier White? Was he named after John Sevier?
After John Sevier.
How about that?
And I'd always thought that would have been a nice first name, but I didn't get it.
Could have been Penny Sevier White.
That's right.
Too severe. Are your parents still living?
They are. My dad, Carmen, he goes by C.A., but his name's Carmen White, lives in Kingsport on his own. He is born in December 1919, so he's 92 and a half years old. And my mother, Jean Bush White, is also living, suffering from Alzheimer's and living in an assisted living facility near my father, but not at the house.
And when you were younger, what did your dad do for a living?
My dad, from the time he became a married man on, was an employee of Eastman, at that time, Bays Mountain Construction Company, which was a subsidiary of Tennessee Eastman. He was an electrician by trade, and that's what he did for Tennessee Eastman Company.
How about your mom? Was she ever employed outside the home?
She was. She stayed at home a lot, but she was really before her time in many, many ways. She was an architectural secretary. She prepared specifications on the old mag card typewriters long before anyone had ever thought of a computer, and detailed typewritten specifications for bids for architects, many architects in and around Kingsport. And she also worked for Kelly Girls occasionally between jobs. But my mom was really a prodigy. She finished high school at age 13. She was fully employed at the Clinchfield Railroad by the time she was 14. And she went to business college. So she was just really quite a woman before her time in a lot of ways.
So from the time you were born, you were aware that women could do lots of things.
That's the interesting thing about my mom. It wasn't just public work or secretarial work. My mom and dad actually built the house, not the house that I grew up my entire life in, but the house that we lived in from the time I turned 13 on. And when I say built, I mean they designed the plans, everything other than laying the foundation. They wired it, they plumbed it, they did it all. So she was far more accomplished in those things that are useful than I ever became, that's for sure.
Now, where did you grow up?
Grew up in Kingsport. The first 13 years of my life I spent in a wonderful little community called West Carter's Valley, which is down near the Holston River in Sullivan County. In the 8th grade, the summer of the 8th grade, my parents moved us to the house that they built, which was a far nicer house, but it was a significantly difficult moment for that point in my life, to be uprooted from, a community where I'd grown up, where we all did everything together as a community, to this new, really nicer area in terms of affluent, but still a place that I didn't quite fit in. So that was a really difficult time for me.
So you grew up in Upper East Tennessee pretty much the whole time.
That's right. Just moved across county.
Penny, do you think that growing up in Upper East Tennessee played a particular role in the person you were to become later as an adult?
Definitely. I've thought a lot about in what way that happened, and really it sounds trite, but it comes down to 2 or 3 things. Growing up in Upper East Tennessee and in the kind of family I grew up in terms of economic status, which was just a working class family, I think I just grew up thinking that what you do is work, and I mean that's good and it's bad, but we didn't have much play. I mean, I laughingly tell the story, it's true. We took, as a family, 1 week every year. We took the same week every year, and we went to the same place. Not only the same city, but the same hotel and the same hotel room every single year. But that was really significant because where I grew up, and this particular hotel was at the beach, Myrtle Beach. But where I grew up, most of the young kids I played with till I was 13 years of age had never seen the ocean. So really, we had it good. But what you did is you worked. When you got home from work in the evenings, you worked the garden, or you painted, or you washed the windows, or for crying out loud, you washed down the wood paneling in the basement. So part of growing up in East Tennessee was just instill that in me, that what you do during your life is you work. But I think the other part is kind of, it's almost like I guess the code of the hills or whatever. People were their word, people were their honor, and you grew up knowing that if you weren't truthful and honest and hardworking, that you wouldn't be respected. And respect was everything, to have people's respect for who you were, not for what you did or what you became, but for who you were. So I do think it was very significant in a good way. In other ways, it was detrimental. I grew up in a situation in which if we hadn't moved when I was 13, going to college would have been a reach. Not because I didn't have the intelligence, but because people where I grew up didn't go to college. They went to high school, they got a job, maybe they got their LPN license and became a nurse, but most people just didn't go to college, and I'm not that old. But I did get that opportunity, but the point I was going to make is that to go to a small local community college or a small college was good enough. We never dreamed about, I'll go to a top 20. We probably didn't know what a top 20 university was. So in some ways, I've always felt that my foundational educational background is a little lacking. The public schools that I went to were good enough, but they weren't great. And so very much it's a part of who I am, both good and bad. Long answer.
Good answer.
Hard
Good
question.
answer.
Hard question.
It explains to me that your work ethic that you've demonstrated throughout your career really wasn't optional.
That's right, but it is sometimes a curse, very much so, a curse.
Now, where'd you go to high school?
In Sullivan County, Sullivan Central High School. Got started with the orange and white early because the colors for Sullivan Central High School were orange and white. It's in Bluntville.
How about your undergraduate school? Where'd you go there?
Yeah, and that fits into what I was just saying. I went to East Tennessee State University, and it changed who I was, and it gave me so much. But in all candor, at this point in my life, when I'm trying to be a member of the academy, having an undergraduate degree from an unknown university like ETSU can be a hindrance. But for me, it was more than a lot of people in my upbringing expected, so it worked out well. And of course, since we're taping this, and who knows what the future will hold, East Tennessee State University is in Johnson City, Tennessee, also in Northeast Tennessee.
And East Tennessee State, for many of us, is really not what we would regard as a small school. And of course, the University of Tennessee was reasonably close to your home as well. But you're talking about Yale and Harvard and those kinds of schools you didn't really think about.
Didn't think about, and I'll tell you why I went to ETSU, and it figures into someone who was prominent in my life, sort of didn't plan to be prominent, but he was a coach at Colonial Heights Junior High School. And he had gone on to become an admissions counselor at ETSU, and he came to Sullivan Central and said, if you make this score, and gave me a raw number, on your ACT, I'll give you a free ride to ETSU. I'll give you a 4-year scholarship. Well, true to just being, basically just getting there, I made that score,
that
not 1 point more. And he gave me a 4-year scholarship. And all of my friends at that point were coming to the University of Tennessee. But I knew financially that while my mom and dad would try to make it work, I couldn't even imagine going somewhere that you'd have to pay for if you had a 4-year scholarship. So I went to ETSU on a 4-year scholarship.
So what do you think he saw in you to make that kind of offer?
I don't know. I had only met him after we moved, and those were difficult times for me. So I don't know. I think he probably made that offer to everybody. I don't think it was. He probably would have given a scholarship to anybody who made that score. It wasn't a low score by any means, but I'm not sure it was unique to me.
When you were at ETSU, what was your major?
I majored in political science, very useful major, as we all know, right? I think by that time I knew I wanted to come to law school. So I majored in political science. Some people used to give that advice. I'm not really sure why. Had a minor in criminal justice, a double major in political science and criminal justice, and a minor in an even more useful discipline, speech.
It is a very useful discipline, I've discovered. They might not have thought so at the time.
That's right.
Now, somewhere I think I heard that you were pretty active in student government when you were in undergraduate school. Am I right about that?
I was. You can't ask me a question and just get an answer. I'd be a horrible witness, wouldn't I, Charles?
No, you're a good witness.
In junior high, during those difficult days, I had been persuaded to run for student government office by a different coach, not the one who offered me the scholarship, but a different one. And myself and 2 young women had done that, unheard of. 3 young women back in the 1970s running for the lead offices in the school.
Did you run as a ticket?
We ran as a ticket. We were soundly defeated by 3 men. In high school, the same 3 women ran against the same 3 men, and this time we won. So that was that was how I got involved in student government in high school. I was not a cheerleader. I was not a member of the band. There were almost no women's sports, so I wasn't involved in athletics. So I spent a lot of time devoted to student government, whatever that means at high school. When you're in high school, you think that's pretty darn important.
And did it carry over to college?
It did. It did. Again, unusual. I was not a member of a sorority. I ran, however, as a non-Greek for president of the student government at ETSU, and was successful. Not the same 2 women this time. I had a Greek guy as my vice president candidate, so got elected. And they say, it's one of those historical facts that's unproven. They say I was the first woman of first woman student body president at ETSU. It's subject to being contested because there were times when ETSU was what they called the normal school and a teacher's college and only had women students. So if they had a government, they clearly had to have had a woman president before. But they acclaimed me as the first woman president there.
Now, you said that when you majored in political science, you sort of had law school in the back of your mind. At what point did you seriously think about going to law school?
8th or 9th grade. for no real reason. I'd never seen a lawyer, never seen a real lawyer, no lawyers in my family. Coach Roger Herron, who taught Tennessee history, had this way of suggesting and he would use the same quote to suggest his overall theme. His quote was, "Speak now or forever hold your peace," which he obviously stole from history. But his point was, you know, it's time, you got to do something or you can't complain about it, or you've got to, if you've got questions about this subject matter, ask me now or don't complain later. And I don't know, it just kind of instilled this sense of duty, I guess, in a way, for a citizen, for a public citizen. And maybe you get that if you're in the military, but I never had that opportunity. So something just stuck that, well, what can I do? And I didn't have a good, strong science background, so I ended up just beginning to say, I'm going to law school. Never, as I said, didn't know any lawyers, had none in the family, but that just became my career objective that early in life.
So when you were in college and going through that process, did you consider other careers as you were going along?
I really didn't. My mother strongly wanted me to be a nurse, and that was brought up to me often, but I really never considered it.
Now, where did you go to law school?
I came to the University of Tennessee College of Law right after undergrad. I spent a short period of time, 2 semesters, working on a master's degree, but really no meaningful career between undergrad and law school.
You graduated from Tennessee class of?
81.
Were you one of those people who enjoyed law school?
I don't know. I enjoyed aspects of it. But I don't really think I would say I enjoyed it. It was stressful. It was challenging. I thought it was very challenging. These students today that kind of breeze through, they just amaze me.
I also went to a small school, and I remember coming to the University of Tennessee being scared to death that I wasn't prepared to compete.
Yeah.
Were you concerned about that?
Absolutely. And I didn't come to law school with many people I knew. And I think, Charles, you had the same experience. The University of Tennessee divides you alphabetically your first year.
Right.
So you often become fast friends with people who are, in my case, the T's, the U's, and the V's, you know, and maybe a few X, Y's, and Z's along the way, because I was a white in law school as well. So you were looking, you know, in college you look around and you know these folks and you know how they've done and you know how you compare, but you're looking at a whole new world of faces. You don't know how you're going to compare. And of course we make it all the more stressful by giving one exam per semester, per course, so you don't get any measurement along the way how you're doing. So yeah, I found it very stressful.
That first semester that you were here, or first quarter that you were here, did you have a little concern that it was country girl come to town?
Absolutely, and that was so reinforced by my legal process 1 instructor, who informed me for the first time in my life that I did not know how to write. You know, I had taken a lot of writing courses with a great professor at ETSU. So then you don't know, did I really not learn how to write? Do I really not know how to write? Am I going to be able to get through this? Oh yeah, it was horrible.
Was it a huge relief to you when you realized you could compete?
It was, but I don't think it ever ended. Every semester or quarter, I would go, back in those days, grades were posted by exam number, and you'd all, you know, I'd drive down here on Saturday if we were on break. You'd get in the door as soon as the door opened and go look, find your exam number and see what grade you made. And sometimes it would be a fairly traumatic situation there in the hallway as people saw their grades. So yeah, and there were semesters when I was at the bottom of the barrel, and there were, fortunately, the others outweighed. But I had some rough semesters here. I remember going in to see one professor and I say here because we're at UT today. But I remember going in to see one professor about my grade afterwards, and it was Durwood Jones, and he just put his head in his hands and he said, I don't know where to start. I just can't help you. Therefore, I did not become a tax lawyer.
Well, Other than Professor Jones, who are the professors at UT that you remember who were sort of memorable to you in your law school career?
By far the best was Professor, and still is Professor Joe Cook. Had him my first quarter, my second quarter, and then took him every single time I could get him, and ended up probably taking 6 or 7 courses from him. Ended up being his research assistant. He intimidated me to death, and he still does. I live for the day that I can get Professor Cook to smile at me in the halls at UT, still today. He is just a giant academically, and a fabulous teacher. So by far my most memorable professor.
So you finished law school in 1981. What was next for you?
Well, I finally got a job, and I say that in all honesty. It was April. We then graduated probably around the end of May on the quarter system, and it was the 3rd week of April. I almost want to say I remember the day that I finally got an interview with the job I took, and that is not to suggest that I had a number of other interviews. I have you talked about East Tennessee having a bearing on my upbringing or on my life. It is a magnet. East Tennessee drags you back. So something told me I had to practice in Upper East Tennessee. So I narrowed my search to there, and I met with a lot of firms who did not have women, who did not want women, and who did not want me. And I remember one conversation in particular with a large firm in Kingsport, sitting across the table from a man, and the first words out of his mouth being, "We both know this is a waste of our time." And so I had a really difficult time getting a job. Now, I was editor of the Law Review, and I graduated high in the class, but I could not find a job. And so this is, I think, helpful, I hope, someday to somebody who's in the same sort of situation. What finally happened is a man who I had worked for 2 summers earlier, who had been legal aid director, and I'd worked for him as a summer clerk. I called him and I said, "I want to go to work for Dick Pechtel, who is a lawyer in Johnson City, and I can't get," I'm sorry, Dick, but it's true, "I can't get Dick Pechtel to return my calls. Can you help me?" And after about 3 or 4 weeks, he got Mr. Pechtel to agree to see me. I went up there and interviewed, and he offered me a job. So it all worked out in the end, but it was horrible. I didn't know what I was going to do. So I know I can so sympathize with people nowadays, the last 2 or 3 years law students who are getting out and not knowing what they're going to do career-wise. So again, sorry, but long story short, I went to work for Richard Pechtel & Associates as soon as I got out of law school, after I took the bar, and it was a small shop, 3 people. Mr. Pechtel, myself, and another associate.
Do you recall whether or not there were other women in your class who had the same sort of difficult experience in being placed?
I don't. I know that a lot of people stayed in Knoxville, and a lot of people went to Nashville and to Memphis, and I feel like their experiences, and I feel like it was easier. I feel like Upper East Tennessee was one of the last places to have lawyers. Now, there were 6 phenomenal lady lawyers. I hate using that phrase, but I'm using it just to be specific here. Women who happen to be, or lawyers who happen to be women, up there at the time. So I certainly wasn't the first, but a lot of them were on their own. The one name that comes to mind right away is Judge Sharon Green, who's juvenile judge there now. She was practicing with her father. Another name that comes to mind is Margaret Fugit. She was up there and she was practicing with, I think, her then husband. So it was a little different. I wasn't going in with a family firm, wasn't going in with my spouse, and I was going to rural East Tennessee.
So you engineered the interview with Mr. Pechtel.
That's a very nice way of putting it. I did finally.
Why did you engineer that interview? What was it about that firm that made you?
I admired him from afar because of his trial work. All I really wanted to do at that time, all I thought I wanted to do was criminal defense. And I admired who he was in the courtroom and the kinds of cases he got. So I just basically honed in on this is who I want to go to work with.
Once you got started, what sort of work were you primarily doing?
I was carrying a lot of briefcases. But I had a wonderful experience. Within 10 days of going to work with Dick Pechtel, we took a first-degree murder case that I would work on from September '81 until 1989.
Wow.
Through a trial and appeal, my first trip to the Tennessee Supreme Court, a reversal, a new trial, and an acquittal. So a case that lasted almost the entirety of my private practice career. So we did a lot of criminal defense work. We did some. He did a fair amount of tort work, and I got introduced to family law for the first time as a young associate in his firm, and that's an area of law that I came to enjoy. Seems like a strange word to use, but it's an area of law that I came to feel very useful in as both a trial lawyer and as a trial judge because of the depths of despair that people are in. It's similar in some ways to criminal because people are really in need of your help and counsel. So I did a little bit of what I always call, walk in the door people law, just helping folks with the problems that they have.
You thought you were going to enjoy criminal defense practice. Did it turn out that you really did?
Loved it. Yeah, absolutely. No question. I'm still an old criminal defense lawyer at heart.
What is there about the criminal defense practice that draws you?
Protecting what could just be lofty claims of privilege and right, protecting those and making sure that they're actually honored, particularly in a dynamic where one side has all the tools and all the resources and the other side doesn't. I guess it sounded like I'm saying the David and Goliath nature of it, although I don't want to compare David to criminal defendants, but basically that's what I'm talking about is that, you're going up against the government and all its power, and they've proclaimed these rights that they're going to give to individuals in this situation, and it's just so easy to let those fall by the wayside. So just being the person who says, no, wait a minute, that's not the way we do it. Just being the voice for someone who a mighty force is coming against.
You enjoyed being a part of the essence of the rule of law.
Yeah, that's very nice. Again, very well put.
Now, how long were you with Mr. Pechtel?
I was with him 2 years, from '81 till the end of '83, or till the summer of '83.
And then what was next?
I was learning a lot, but no one was ever going to walk in the door to see me. And I was always going to carry a briefcase, and I just didn't have it in my gut, in my soul, to carry a briefcase forever. And while I was at UT, I had taken a number of legal clinics, and as a result, had gotten to know some of the legal clinic professors here, who were also memorable. I didn't mention them earlier, but they were memorable. But out of the blue, one of my former law professors, Dean Rivkin, contacted me. I ran into him or something. I don't quite understand or remember what, but he said, Penny, there's this program up at Georgetown Law School, and you'd be great for it. And it was right about the time I was getting antsy and wanting to do a little bit more and realizing that I wasn't going to get to. So I remember that the timing was such that the application was due. I mean, it was pretty dramatic, but I managed to get the application done. Was also,
the application
the application to go to Georgetown Law School to participate in this so-called E. Barrett Prettyman program, a fellowship program. And it was complicated by the fact that I was also getting engaged at about the same time. And the person I was becoming engaged to lived in Tennessee, and of course Georgetown Law School is Washington, D.C., and there were all these complications. So I applied for the E. Barrett Prettyman Fellowship and sort of forgot about it, and then lo and behold got an interview and got the offer. And it was fabulous. They'd never taken anyone from the University of Tennessee before. They only choose 5 a year. It was fabulous. But now what am I going to do? I've got this guy in Tennessee. I got this offer in Washington. Ultimately, we decided that we would move to Washington and I would take the opportunity to be an E. Barrett Prettyman Fellow. So I went up there for 2 years, and it definitely changed my law life because of just the in-depth, intense training that you go through in that program. It is geared toward training clinical law professors. The program was funded by E. Barrett Prettyman, who was a district judge in the District of Columbia, who I guess borrowed Chief Justice Berger, I think it is, phrase that many lawyers were walking violations of the Sixth Amendment. And he said the way we're going to make lawyers not be walking violations of the Sixth Amendment is we're going to train them in law school to be lawyers. Imagine that. So he put this money out to fund this program so that people would come to Georgetown and learn how to be clinical teachers. So that was the basis of the program. But the backdrop is that you represent
Let me interrupt you
clients.
there, and let me ask you this. You talked about walking violation of the Sixth Amendment. I want to hit that because was he talking about the effective assistance of counsel and the lack of that?
Absolutely. And this was in the 60s. This was long before we had any had the sort of modern jurisprudence that we have on the effective assistance of counsel. So he funded the program to train clinical law professors to go all over the country and prepare people to be good criminal defense lawyers. So the program at Georgetown does just that. It brings 5 people in a year so that there are a total of 10 fellows at any given time because it's a 2-year program. And these people learn to be clinical law professors while representing indigent defendants in the courts in the District of Columbia. So I did that for 2 years under the tutelage of Bill Greenhall, a fabulous professor at Georgetown Law School, and learned about turning every stone when you're representing a client, about looking everywhere, looking under every stone, looking through every door, doing everything possible to render effective assistance. And it changed the way I thought about the practice of law, or it changed the magnitude with which the responsibility for representing a person in a court. It changed my idea of the magnitude of that responsibility.
When you were doing that, when you were serving as a Prettyman Fellow at Georgetown, did you realize while you were doing it how much fun you were having?
Oh no, this was the worst because being the only Tennessean, they made fun of me from the day I got there. They made fun. At that time, I was a little modest. They made fun of the way I talked. They, being my fellow fellows, they made fun of the way I talked. I remember being laughed at McDonald's trying to order food. I never lived away from East Tennessee, and I felt like was sticking out like a huge sore thumb in terms of being, that country bumpkin or whatever. But my fellow fellows would use some salty language and look, and I would blush, and they laughed to this day. There was an article written at one point in my career about me in which one of the fellows said that we cursed just to watch her blush. I mean, they took advantage of my naivete at every level. And it didn't help that Greenhall said the reason he had offered it to me is because he thought I sounded like Dolly Parton. I mean, so that didn't really build my confidence. But no, I didn't know I was having fun. I did not know I was having fun, and I didn't know it was changing my life. But I was working hard.
But in retrospect, were you having fun?
Oh yeah, what a great experience. And I'm happy to say that they've now had 2 other Tennesseans. So there have now been 3 Tennessee Prettymen in the course of the program. One of them is a very recent grad, so we're proud of that.
You taught them what Tennesseans could do,
That's
didn't you?
right.
Now, did you do any academic, I know you were working in the clinic, but did you do academic coursework at Georgetown as well?
Yes, each fellow had to take only 12 hours of classroom study, and those were 6 hours were dictated. One was a pedagogical course on how to design clinical teaching and so forth. The other was a intensive trial training course, and the other 2 were at your choice. So you took whatever master's level courses Georgetown Law School had to offer that interested you. And then if you desired to get the degree, which it wasn't mandatory at all, many people don't, but if you desired, then you had to write a dissertation. And what would be a better topic than the right to counsel, which is what I wrote my dissertation about.
a logical thing, I think.
That's right.
Have you been able to stay in touch with your fellow fellows, as you refer to them?
Yeah, I actually have. We have reunions, so it happens occasionally. I tell you, I've stayed in better touch with the staff. There were two administrative secretaries up there who I still, every time I go to D.C., I go over to the law school just to say hi to them because they're still around. So I maintain some contact with them.
Now, I see on your resume that you have a Master's of Law degree from Georgetown University. Is that the natural outcropping of the Prettyman Fellowship?
That's right. Upon completion of the dissertation, you get the LLM in advocacy.
Now, did you come back to East Tennessee when you finished your fellowship?
Yeah, that magnet just drugged me back. I applied for teaching positions, which was supposed to be the natural evolution of what you do next after you get that LLM. I got a few offers, none of which interested me. So I came back and I rented an IBM Selectric 3 typewriter from Mr. Pechtel. And I took my last Prettyman check, and we made $13,000 a year. So I took my last Prettyman check for $1,100, and I rented a room, and I nailed a shingle up, and I started practicing law.
Solo practice.
Mm-hmm.
What type of law did you practice? What did you do?
Anything that walked in the door. I did a lot of family law. I did a lot of court-appointed work. Back then, we did not have a public defender system. That's what I'd actually written my dissertation about. So I took a lot of appointments, just showed up at the courthouse, got the appointments. I did work, I let the law firms in Johnson City know that I was available if they didn't want to write a brief or if they had a conflict in a case. So I took referrals, tried to get referrals, and ultimately grew from that one-room office to a couple-room office, and then ultimately bought a building for my firm.
Were there other women who were solo practitioners in your area?
Probably. Can't think of anybody right offhand, but probably, because if you can't get anybody to hire you, that's what you do. I'm not saying that was my situation at that time, but at that time, when I started my own practice, I wanted to practice on my own. I wanted to be in charge of taking the cases and deciding how things were to go. But you know, obviously, as I think a lot of people are finding out these days, that is one avenue for people who don't get offers.
Did you take a lot of appointed work at that point to build a practice?
A lot of appointed work, criminal, and interestingly enough, the legal services office, where I had worked after my first summer in law school. At that time, legal services was structured a little differently from what it is now, in that they could take cases that might generate fees if they were successful. Nowadays, they don't do that. But they had taken on some cases, particularly involving jail conditions, that were becoming overwhelming to them. And so within a short amount of time, they contracted with me to do the trial work on those jail condition cases. So I began to develop a specialty in civil rights litigation, in jail conditions law, and in prison litigation. And that, again, was before the reform of the Prison Litigation Reform Act, which has pretty much stamped out a lot of that litigation. But I was getting a lot of federal court work by virtue of those referrals from legal services and that contract work from legal services.
Do you think your experience at Georgetown gave you some confidence to come back and go solo that maybe you didn't have before?
I think that's likely. Yeah, I think that's very likely.
So I'm told, and I think I've heard this right, that you are one of a small group of lawyers who has argued a case before the United States Supreme Court. Now, is that right?
That is correct. Just one.
It's one more than I've had in a career. When did that happen?
Let's see, 1988. Didn't I figure that out? Yeah, 1988. So I got back from Georgetown in 85, started my firm in 85. And 3 years later, it's, I need to answer your question, but I'll tell you, it's an unusual connection to what I just said. Some of the jail litigation that I got involved in was successful and settled, and some of it was tried. And one of those cases that we tried and were successful in was appealed to the Sixth Circuit. And at the time, the Sixth Circuit Court of Appeals in Cincinnati. And at the time, I was not licensed in the Sixth Circuit. So I filled out an application to be licensed. It's simply a matter of filling out an application and paying your money. But on the Sixth Circuit application at that time was a little block that said, will you accept appointments? And I, of course, checked yes. And within literally a few days, I got an appointment from the Sixth Circuit in which they were asking me to look at a case in which the pro se petitioner had filed in district court, lost, and appealed to the Sixth Circuit. And they believed his appeal to be out of time. They believed it was late. So they appointed me to brief whether his appeal was late on behalf of Prentice Houston, was the petitioner's name. Right. So as a result of that appointment, I did what I had to do in the Sixth Circuit. I went to the Sixth Circuit. I stood up to argue the case, the first time I'd ever appeared there. And before I got literally, my name is Penny White, I'm a member of the Tennessee Bar, I noticed that the three judges began talking, which I thought was pretty rude. You know, I'd come all the way to Cincinnati. I probably had a new dress on or something, you know, new suit, and they're talking, looking back and forth. And finally, the judge in the middle said, Ms. White, you know, pursuant to Internal Operating Rule 16, and because I'm obsessive compulsive, I had read all the rules, so I'm going in my mind, 16, which one's that? And about the time he said it, I realized that he said, we summarily affirm the dismissal of this case. We do not need to hear your argument.
Oh my.
So I'm shut down immediately before I even get to make my argument in the Sixth Circuit. Well, unfortunately, they had another rule, and it said if you're appointed, you must petition the United States Supreme Court for certiorari. So I did, and they granted it. Now, you can't make this stuff up. So that was how I got to the U.S. Supreme Court.
How old were you at that time?
32. 32.
And you'd been practicing law at that time for 7 years?
Yeah, about 7 years. Yeah. You know, when you, so you petition the court and the court grants cert, but then that still doesn't, so you can be the lawyer then, obviously, because you filed the cert petition, but it's expensive to appear in the U.S. Supreme Court in the sense that you're expected to print your briefs and it's time consuming. So I wrestled with myself for a while about whether I wanted to request the U.S. Supreme Court to actually appoint me, because once they do so, they will pay for your printing cost, and they will also pay a small fee for your representation. And I had been advised that there were a lot of people who wanted to be appointed to argue in the Supreme Court. And bear in mind, this is way before the development of this sort of boutique Supreme Court bar of these people who do all the arguments in the Supreme Court. This is when an everyday Penny White could still end up in the Supreme Court. So I went back and forth in my mind, and eventually I decided I cannot afford to do this without being appointed. So I made the motion for appointment, and Chief Justice Rehnquist appointed me, probably because it was so close in time that someone else wouldn't have had an opportunity to get up to speed on it. So I ended up getting appointed by the Supreme Court, but that was after the petition had already been filed and accepted.
So you're a 32-year-old lawyer in front of the United States Supreme Court. Who do you go to say, what do I do?
I came right to this building, the University of Tennessee College of Law, and I went right to Georgetown. And I also went to the hills of Upper East Tennessee. I did 3 moot courts with the UT law faculty, with the Georgetown law faculty and the Prettyman people, and with the lawyers of Upper East Tennessee. I did three practice moot courts.
And how long was it before you actually had your oral argument that you knew that you were going to be arguing this case before the United States Supreme Court?
It's also a very unique situation. They granted cert in my case over the holidays in December. and late December, maybe even the first week of January. And my oral argument was April 24th or April 27th. It was the last day of the term, so I believe it was April 27th. So we were the last case to have cert granted and the last case to be argued, so there was about a 4-month period. And in that time, there was also a brief that had to be filed, a merits brief and a reply brief. So it was really a short timetable.
When did you ever sleep during that period of time?
Yeah,
Were you trying to maintain the rest of your practice at this time?
Yeah, I was, but not so much. I certainly wasn't taking anything new at all.
Do you know how much you got paid for this effort?
Yeah, I got $500. I got $500.
If you would, think back to the day of the oral argument itself.
I hate
remember
to
what you
admit,
felt
it's
like?
so easy. I can tell you everything about that day.
Tell me how you felt.
Oh my gosh. Scared, awestruck, after it was over, relieved, exhilarated. I had these anecdotes may get old, but this is one that I can't not tell it. I had a new pair of shoes. I was going to the Supreme Court. I probably had a new everything. And I had walked from the hotel. And I had worked a groove into the back of my foot so deeply that I was bleeding. Well, the Supreme Court has its own nurse. Who would have known it? So when I get there and I check in, I'm the last argument of the day, but you have to check in the morning. So I check in and then I go to the cafeteria, and I have sort of a disrupting situation in the cafeteria. I kind of drop my tray, and Justice Blackmun is in the cafeteria with his law clerks, and he sort of looks over at me like poor pitiful creature kind of look. So anyway, I get all put back together, and someone says, you need to see the nurse. You've got blood up and down your leg, up and down your stocking. So I go to the nurse, and you'll see why this is an unbelievable story. So she takes care of me. She cleans my stocking. She bandages me up. We get to talking. She is Elsie Range. She is the wife of Harry Range, who founded the Range Medical Clinic in Johnson City, Tennessee. I mean, it was almost like an angel, So she's so kind and so gentle. So I go through the rest of the day. It's time for me to argue. And what I remember seeing out off my right shoulder when I stood up to walk up to the table was Elsie Range standing in the back of the United States Supreme Court. And I don't know whether it was that or one of Justice Blackmun's opening questions. One of Justice Blackmun's opening questions to me was, I've never quite felt that we treated poor people fairly in this court. And that was the essence of my opinion. And from that moment on, I just felt buoyed with strength and compassion and just with guts. And my professor, who I mentioned a while ago, Bill Greenhall, came to observe, and he said to me, the first thing he said to me after we left was, "Has Blackmun proposed yet?" And it was weird because he gave me a gaze of encouragement from that question on, and he really turned out to be an incredible force. My father, after I went on the bench, wrote him a personal note, and Justice Blackmun wrote him back. And so I've just always felt this unusual connection with him. But clearly, not all of the argument was peaceful. It was a pretty vigorous debate between Justice Scalia and myself, a pretty heated debate, which Blackmun ended up describing as being like a fight. So I guess from the observer's point of view, it was pretty vicious. From my point of view, it was like that. I stood up, I spoke, I sat down, and the fact that I didn't pass out in the middle, I consider an extreme accomplishment, and that's how it felt. It just buzzed by. So it was, I never wanted to do another thing. I just wanted to go home, put my feet up on the couch, and think about it the rest of my life. It was a great experience.
Now, I've heard that the press reported, after your argument there, the press reported some feedback about your performance in the Supreme Court. Do you remember that?
You're trying to make me look so immodest.
I'm doing my best.
I do remember.
It's hard to do.
But it too came about in a roundabout way. I got a call in my little office in Johnson City from a woman who claimed she was a member of the D.C. Bar. Don't remember her name, but she said, I heard Justice Blackmun give a speech today, and he mentioned you personally, and I just thought you wanted to hear about it. Well, I thought she was one of my Prettyman colleagues pulling my leg.
Right.
So I said, yeah, right. And she got a little bit offended and basically hung up. Well, as it turned out, that had happened. Blackmun had been given a talk at a meeting. I think he did it more than once. And he was using my argument as the backdrop to complain about Justice Scalia's uncivil treatment of litigants of advocates before the court. And so Justice Blackmun compared Justice Scalia and I to fighters, and basically the way he described it, I got the better of Scalia in the end. So it made news, and then I just
made news in the New York Times, didn't it?
It made news in the New York Times, yeah, it did. But then, the amazing thing is 20 years later, they repeated it in the New Yorker magazine. So like I said, sometimes sometimes I just get great things happening to me for no reason whatsoever. But yeah, it was, I don't know that the argument was as good as Blackmun has made it out to be, but it was nice to have that happen, obviously.
It's good enough to win, wasn't it?
Yeah, 5-4 with Scalia dissenting.
So could you have predicted in advance that this was going to be a 5-4 opinion in your favor?
I couldn't. And I think historically we've become much more attuned to predicting how justices will view based on what we think their personal and political philosophies are. I did not have that knowledge of the court at that time, nor do I think we had that tendency, we being meaning lawyers, we did not have the tendency so much to predict. But I will tell you this, and this was shared, this I learned not through my own knowledge, but through my then husband. Brennan wrote the opinion, and I was told that meant that it was a struggle. For Brennan to actually write the opinion probably means that's who had to write it to get the 5th vote. But let's not make it bigger than it was. The New York Times said it was the least significant case of the term. So we don't want to create any misimpressions here that we did anything really significant. We did get through it.
How significant was it in your career when you got back home?
Yeah, well, like I said, I didn't ever want to do anything else. I doubt that many people in Tri-Cities knew about it or know about it, but heaven knows I'm proud of it. I'd love to go back. I've tried on 2 occasions to go back, and both times they've denied cert, but I would love to go back.
I would think that when you win a case in the Supreme Court, the lawyers in your area are going to send you some business. Did you think that happened?
I don't. But then again, the opinion came down in mid-'88. I practiced another year and a half, and then I started running for the bench. So, no, I don't really think it brought me business. But I also don't think it got near the publicity at home as it got afar.
Was it in the Kingsport papers?
Not that I remember.
So it made the New York Times, but not the Kingsport Press.
I don't think it made the Kingsport Times or the Johnson City Press. I could be wrong about that, but I don't remember it. The decision came down while I was out of town, so maybe that was it. I just remember we were out of town when we learned that the court had ruled. So
having capped your career at the bar, you decided it was time to go to the bench.
No, you know what made me decide it was time to go to the bench was...
What did?
Well, I actually, 2 things. One thing, because of the wonderful experience I had at Georgetown. When I was at Georgetown, I was practicing in Maryland, so I was probably appeared before 60 or 70 different judges in the metropolitan counties surrounding the District of Columbia. And then coming back and practicing in a lot of Northeast Tennessee, not as far down as Knoxville very often, but occasionally. I had been before a lot of judges, and I just felt like that there could be some improvement in the administration of justice. And in particular, and the second reason, I was tired of being treated differently because I wasn't a man. I was tired of appearing before jurists who seemed to still not get it that women could be lawyers and could be good lawyers. I won cases because judges treated me poorly, don't get me wrong, but I just decided there needs to be some improvement in the administration of justice. And I'm not suggesting it's any one person on the bench or any one person but I did see a great deal of difference in the judges in Maryland where there was great diversity on the bench, gender and ethnic and cultural diversity, and the judges of East Tennessee. So I just decided I think I can make some improvement here. And I also was a little weary of the difficulty of having a solo practice, of running it on your own, never being able to be away, always being worried that something was going to happen. Plus I was a workaholic, so unfortunately I had made the wise decision to put my office in my home, so if I heard the phone ringing on a Saturday afternoon and I knew some huge crime had been committed on Friday night, I was going to go get that phone call, you know. So I needed to make a change in my life.
Now, were you a part of that first sort of large wave of women coming out of law school that
Probably
more heavily populated the bar with women lawyers than before?
Yeah, probably. I think the number that sticks in my head that makes it easy to put in perspective is when I became a trial judge in '90, there were 9 women trial judges in the state of Tennessee. 9 out of what was then about 180, and I'm talking about courts of record, so I'm not counting Sessions Court, but for the courts of record, there were 9 women at that time. So the number of lawyers obviously was proportionately small.
Well, we've been talking for about an hour about your career. Let's come back in a few minutes and talk about your career on the bench.
Okay.
Just before the break, we were talking about you making the transition from practicing lawyer to the bench. And in 1990, you made that first transition from your law practice. Was that part of a long-term private plan that you had, or just a whim?
Well, it wasn't a long-term private plan. It was a 6 to 9 month decision-making process, partially motivated by the fact that judge in the 1st Judicial District, which is Washington, Carter, Johnson, Unicoi counties, had announced his retirement. And it's not any secret to most people, most lawyers in Tennessee, that it's hard to run against an incumbent. It's always better to run for an open seat. So once Judge Jack Music announced his upcoming retirement, I started thinking about it. And that was, well, I remember precisely that it was in the fall because we were traveling to Don Payne's TLI program when we began to talk about it, some of us in the car, and made the decision about then, so that would have been September or October of '95, and then the election was in August, of 89, excuse me, and then the election would have been in August of '90.
Was it a contested election?
Oh, it was, very much so.
Do you have any good election stories you can tell us?
I have some good election stories. It was my first foray into politics of organized kind, which is not to say that judging is politics, but getting on the bench certainly is. So I borrowed a pickup truck and put some sideboards on it with a hand-painted Penny White for judge. I traveled the 1,200 miles of the 1st Judicial District, literally knocking on doors, and we had a brigade of individuals who would meet on Saturdays for breakfast and go out and knock on doors for months, literally, trying to cover as many houses as we could. This was pre-Google, pre-everything, and so we had spent literally days going through the voting records of all 4 counties to identify frequent voters, and then taking maps of all 4 counties and by hand figuring out which were the best walk routes to hit the most likely frequent voters in the few hours you would have on Saturdays. Lots and lots of pancake breakfasts and ham suppers and lots of political etiquette issues. For example, in Upper East Tennessee, you don't campaign on Sunday. You might visit another church besides your own, but you don't knock on doors on Sunday, or at least you did in 1990. I guess a good story. I mean, you can't hide the truth. It's a little nasty, but my opponent was a married man with 2 children, and he was coached well by very powerful political people, including Lee Atwater.
So were these partisan elections? Were there party politics here?
Not in name, but everyone was well aware of the political alignment of my opponent, and everyone presupposed my political alignment. So we did not have D's and R's on the ballot, but people identified the candidates as either a D or an R. So his campaign slogan was traditional family values, and my campaign slogan was the qualified candidate. And some people have suggested to me that was arrogant, but my point was I had counted every case I had ever tried, and I had counted every case that was of record, and I had counted every case he had appeared as of record, and I used graphs, and he was a real estate lawyer, so it was disproportionate. So I was saying I was a qualified candidate. Well, anyway, on one occasion he was giving a talk in which he indicated that I was unqualified for the bench because I did not have children. And I was there, and my then spouse was there, and I was, to use a country phrase, blowing a gasket. I was about to come out of my seat. I was so angry. And my then spouse was patting me on the knee saying, keep on message, don't lose your calm. So I got up, I ignored what he had said, and I gave my stump speech. The next night, there were 2 political events, probably 2 Ruritan Club meetings or something like that. So I went to one and my spouse went to the other. And the word travels back to me that when he is addressing the crowd on my behalf, he tells the crowd that he would like to address the fact that my opponent seems to be suggesting that since my ovaries don't work, nothing else must work either. So he is here's the man going crazy over the criticism of his wife after he had told me basically to stay the course, keep the stump speech. So my opponent tried very hard to make a big deal out of the fact that I didn't have children. And if you don't have children, you can't be smart enough to be on the bench. So that was kind of the theme of that campaign. There was another occasion in which the local radio station had a call-in show, and someone called in to ask whether either of us had ever used recreational drugs, kind of taking after the old United States Supreme Court confirmation. And my opponent at that time suggested that we should all reveal our pharmaceutical records, to which the radio commentator said, well, this is 1990. He said, well, I don't think many recreational drugs are drugs that you have prescriptions for. So it was a very heated, ugly campaign, but I guess for that campaign I would have to say all's well that ended well, so we came out all right.
Do you recall how much you had to spend in that election?
It was in the neighborhood of $30,000. It could have been $35,000, but it wasn't much more than that. This was a 4-county race. There were some television advertisements. There were obviously some radio advertisements, but money was spent on things like, yard signs, billboards, and cards to hand out, and bumper stickers. So it wasn't a huge amount like we see on television advertising today, but there were some TV ads.
Do you have any concept of what it would cost to run for a contested circuit judge seat in that area today?
Probably 200, maybe $250,000, depending on how contested it was and how many contestants, I guess.
So, after you were elected as a circuit court judge in 1990, were there other women in that area serving as trial court judges as well?
The closest female judge was Judge Mary Beth Leibowitz here in Knox County at that time, and that was, you know, that was another difficulty of the campaign. When I got married, I kept my father's name. I kept the Penny White name. I had practiced under that name for some years, and my spouse was often, you know, with me and therefore called by my last name. And that's just kind of a thing of the times back then. People didn't expect women to have a different name, and he always had a very good response. He always would say, I have my father's name, I don't see why she shouldn't have hers, which I thought was quite classic. But no, women were an anomaly in political office at that time. Now, you said trial court. Judge Shirley Underwood was a judge at the time I became a judge, and many years before I became a judge, and many years after I ceased to be a judge. So there was a woman judge. She was a juvenile court judge, but she was selected by a different process.
When you took the bench, I've always heard judges say once they took the bench, their jokes became funnier and they became smarter. Did you perceive that you were treated by members of the bar any differently than other trial court judges because you were a woman?
I think any new judge is subject to being tested by the advocates to see how far they can push and how much control, not all advocates, but some advocates, and how much control the judge is going to be exerting over her courtroom and over the process. I had only a couple of very insignificant incidents in which I think that treatment was related to gender. But I do think that, like any new judge, I was subject to being tested. And I tried very hard to be aware of that and not, you know, and keep enough control to be the judge, but not be overpowering or overbearing.
So did you have any special training when you took the bench?
You know, don't you know they lay you down and they take that syringe and put wisdom and patience and everything else into you when you become, and the ability to decide who's telling the truth and who's not telling the truth. No, I felt like I had on-the-job training by having been before some really, really good and some really, really bad judges. And I felt like I'd been before a variety of judges, more than a lot of people who hadn't had the wonderful opportunity I'd had to practice in a metropolitan area like the Maryland suburbs around D.C. But the real on-the-job, the real training came, and I would have to say my hat would have to be off to the Tennessee Judicial Conference. Once you become a judge in this state, and in all states really, you attend 3 or 4, maybe more, legal education or judicial education programs, and not only are you being taught, but you're also networking with. You're meeting those people who you can pick up the phone and call. We had a mentoring judge program when I went on the trial bench. I had a wonderful mentor judge, George Garrett from Sullivan County, who died way too early in his life while he was my mentor. But you were connected with someone, either formally or informally, who you could call and ask, and you were also going to education programs 3 times a year, and to the National Judicial College, which is where I also went as a young judge and got quite a bit of training, and I'm still associated with that institution to this day, 22 years later, even though I'm no longer a judge, as one of their faculty members. So the opportunities really come post-election, but there are many opportunities to help you be a better judge once you become a judge.
Now, you were only on the trial bench a couple of years. Do you have any really unusual or memorable cases that you can tell us about during that time?
Yeah, I do. I'd like to tell you about 2 if I could. One's very short. one of the things that you want not to do as a trial judge is for things to become routine, particularly things that are routine. In other words, uncontested divorce day may be a day where you hear 100 or so divorces, and for those people coming in your courtroom, that may be the only day they're ever in court. And it's so important for them to feel the sense of justice and the sense of formality and everything that we want people to feel about the court process. But it's also very easy if you're hearing the same memorized questions 100 times a day to not even look up. So I always try to be aware and to look up and to eyeball the participants. And on this particular day, it was Carter County. This could not happen anywhere but Carter County. Maybe we're halfway through the day. I don't recall exactly, but I had this book that I wrote down every case I heard in, just to make a note so that I would remember once the judgment or the order came in that I had heard that case, just as a safety valve, pre-computers again.
Let me interrupt you 1 second because you referred to Carter County, and for the folks in West Tennessee, they may not realize the rural aspect of Carter County. How would you characterize Carter County?
Oh man, you just got to go there. So Carter County is Elizabethton, Tennessee, and it's beautiful. It's a little mountain hamlet.
But predominantly rural.
Very rural, and it's just unusual. You just got to go there.
I'm sorry for interrupting. Now tell me about your case.
Actually, Judge Robert Taylor was from around Carter County, the federal judge. But so we're on maybe divorce number 50. I don't know, irreconcilable divorce. And in those days, the words were basically, or the phrases were basically, you filed for divorce on the grounds of irreconcilable differences. You've signed this marital dissolution agreement. Do you think it's fair and equitable? Do you want the judge to approve it? Bang, that was it. You're divorced. So we get to the third question. You've signed this marital dissolution agreement. Do you think it's fair and equitable? And the woman says no. So I'm looking down, writing, and I look up and no, and her lawyer says, you don't think it's fair and equitable? And she turns to me and she says, no, not given the lying, cheating son of a bitch that he was. So I bound back in my chair a little bit further, and the lawyer coughs or something. He says, well, do you want the judge to approve it? And she stops and she looks at me and she says, Your Honor, can you award body parts? That, was like, I think it's time for a recess. But that's only Carter County. But my other favorite story, I think it's good for judges to always bear in mind that they cannot take themselves so seriously. And this was early on in my judicial career. I had Johnson County. Johnson County is Mountain City. It is the northeasternmost part of the state. It is, I've always been told that it's closer from Johnson County to Canada as the crow flies than it is from Johnson County to Memphis. So that gives you a sense of this state. And let's say we said Carter County was rural. Let's say that Johnson County makes Carter County look very metropolitan. So I had Johnson County in January, and I don't care what the weather is. It's going to take you an hour from Johnson City to Johnson County if you're making good time. It's very narrow roads, windy roads, beautiful mountain roads. So when I get to court that January, it turns out that the county commission is using the courtroom. Now this may have been a situation where if I had been a male judge, that wouldn't have happened. I've never thought about that before. But when I got there, they just basically said, well, Judge, we have a county commission meeting. So you're in this conference room. So I didn't push the issue. Maybe I should have, but I knew that I was going to have to do certain things to maintain order in that room. And it also turned out that the case I was trying that day was a property dispute. And if you're from the country, I don't care if it's a foot, it's your foot. And you don't take my foot of ground. Well, it also turned out that I was trying it with a pro se, an older man who was representing himself. So I had decided how I was going to run this case, and to make sure that the pro se was treated fairly, but that I didn't help him too much, that the lawyers were treated fairly, and that we got all this done in this room that was anything other than appropriate for holding court. So we were all in and sitting down, and the pro se person is an older gentleman with bibbed overalls, with really a distinctive face, with the tobacco stains from years and years of use, just a classic face. So I go into the courtroom, I tell everybody be seated, and I start to talk. And as soon as I start to talk, this man stands up and he says, "Little lady, little lady." I've never particularly liked the phrase lady, and when coupled with little, it just, so I said, "Just a minute, sir. You will be quiet," or something to this effect. "Just a minute, sir. I am speaking, and when I finish, I will hear you," or something, probably. So I finished all this stuff about how I was going to handle this proceeding, how I was going to be fair, how I was going to do this, blah, 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 blah. And then I turned back to him and I said, "Now, sir, what is it you wanted to say to me?" And he said, "All I wanted to say, little lady, is everybody ought to love Jesus." So, I mean, yes, it's odd, but what that said to me was, get over your own self, Penny. You know, come on, just relax, be, chill. Don't take yourself so seriously. So we proceeded on with the trial of that case.
Did the case go well following that?
I have no idea. I have no idea what happened in that case. I have no idea.
So, following your brief career as a trial judge.
It wasn't that short.
2 years.
Tried a lot of cases in 2 years.
You next go to the Court of Criminal Appeals. How did that appointment come around?
Well, another fluke, to put it succinctly. A colleague of mine on the circuit court bench, or a colleague of mine who was actually a chancellor in the First Judicial District, suggested to me that I should apply for the vacancy created when Judge John Byers retired from the Court of Criminal Appeals. And there's a nice connection there. I always like to say that Judge John Byers is the reason I was able to become a lawyer and a judge, because he was the juvenile judge when I was growing up. So anytime you even looked crossways at your parents, they would say, "You better straighten up or I'm going to take you to Judge John Byers," and you would straighten up. That was the reputation he had. So he was retiring, and my colleague said, "I really think you should apply for this position on the Court of Criminal Appeals, Penny. There's no way you're going to get it, but you're young enough as a jurist that you need to get your name out there in this nominating process that was then the process used for appellate judges in Tennessee." So I did. I took his advice completely, and in hindsight, I loved the trial bench. I absolutely loved it. I can't say it's better than the Supreme Court. I can't say I enjoyed it more than the Supreme Court, but there is no question that I enjoyed it far, far more than the intermediate court. So it wasn't that I wanted to leave, but he suggested that I should apply, and so he said, "Well, are you that much of a noodle that somebody tells you to do something, you go do it?" I mean, in all honesty, it was also partially about being a woman. That was 1992. Tennessee had been around for 200 years, and we'd had one female appellate judge in our history. And that was Judge Daughtry. At that time, she was Justice Daughtry. And I don't know, it almost sounds too arrogant, but the point is that I felt a responsibility to have women have a fighting chance for some of these positions. And I felt like I really did not feel like I would ever get that position. I didn't want to leave the trial court. I say often, if I hadn't left the trial court, I'd still be there. I'd still be there because the lawyers in East Tennessee liked the way I tried cases, and I liked them, and we got along well, and unless I'd gotten old and crotchety, I think I'd still be a judge. But everything else is fate. I applied. I remember I was so at war with myself about it. I remember talking to my dad on the way down here. The interviews were held here in Knoxville at the hotel downtown, and we were driving down from Johnson City early that morning for the interview. And I had talked to my dad, and I said, "Dad, I just don't know about this." And he told me a story about wanting to work for the United States Post Office and never getting a chance, and then getting an offer after he got on at Tennessee Eastman, and having that pull with himself as to whether to go to the post office or stay the course. And I'm not really sure, I don't think he really advised me withdrawal. I think he probably said to me, do what your heart tells you to do, but for whatever reason, I went on through with the interview and got the appointment.
Was it a surprise to you when you were the one selected?
It wasn't a surprise to me after I made the 3. The
Okay.
fact that I made the 3 was a surprise. What was most surprising about the process is that after I made the 3, I never met the governor. And I do think this is historically important because of where we are sitting here in 2012 and where our courts have come in terms of being politicized. I had never met Governor Ned Ray McWhorter, had never shook his hand. I had never laid eyes on him in a room other than on a television when he appointed me the Court of Criminal Appeals. I got a call from Harlan Matthews, who was his assistant, telling me that the governor was going to appoint me, and that was it. I'm struggling to remember who the 3 finalists were, but I know without remembering precisely, and I don't want to say and end up being wrong, that I was the only one of the 3 finalists who had the three things I had going for me that I think attracted McWhorter, is that I was a female, and McWhorter did want to promote and was being encouraged by many women in Nashville, including Justice Daughtry and Margaret Bim and others, to get more women on the bench. So I had that going for me. I was a trial judge, so I had experience, judicial experience, but more than judicial experience, from the point of view of a governor, I had a position. So once I got appointed to another position, there was a position to fill. And thirdly, I had won by large margins in a very, very Republican area of the state. And here's a Democratic governor who is at a time politically anxious to have even more allies. He had a lot of allies in Upper East Tennessee, but to have even more allies. So he benefited 3 things. Did any of those have to do with my ability to be a good judge on the Court of Criminal Appeals? No. Of course not. They didn't.
So as one of the 3 finalists in this race, you were not interviewed personally by Governor McWhorter or by anyone on behalf of Governor McWhorter?
Not for the Intermediate Court of Criminal, not for the Intermediate Court, no. Never was.
When you got to the appellate bench, did you have to make any significant adjustments moving from the trial bench to the appellate bench?
It is night and day. It is so different, and it was so challenging.
Why so?
Well, the volume of work was completely overwhelming. At the time I went on the Court of Criminal Appeals, we only had 1 judicial clerk each. There were only 3 judges, and given the number of opinions that each judge needed to average each year to keep their docket up, you had to write somewhere between 2 and 3 opinions every week. Now that sounds like nothing unless you start remembering, or you stop and remember, that this is the Court of Criminal Appeals. Every single convicted defendant has a right to an appeal in this court, and the records can range from, well, every single convicted defendant who hasn't pled guilty. And the records can range, obviously, from 1 volume to a room full of volumes. So you might have a record that it takes you literally 2 weeks to read, and then you're already 4 opinions behind. So the volume of work was overwhelming. I had some, I had good, solid criminal procedure thanks to Joe Cook, criminal law background thanks to my practice. So I was not swimming upstream for the subject matter, but I was swimming upstream for the volume of work and the nature of the work, the idea that you're no longer fact-finding, that you're taking facts as found by the lower court, that you're looking at legal issues, but you're only applying precedent, so you're not really deliberating and thinking about what the law should be. You're trying to make sure that you that you apply what the law is. So completely different from the trial bench. And as much as I love him, I had a giant of a colleague who was very, very demanding and very intent on making me the best judge I could be, even if it took, you know, I'm having a vision of him now as a schoolmarm with the little pencil making you rewrite every one of your A's so that they look just like the A's that they're supposed to be. And
Did Judge Tipton actually make you do that?
That's Judge Tipton. No, but what Judge Tipton did make me do once was write 13 drafts of one opinion.
Wow.
So when you say you write 2 opinions every week, that's to stay on top of things. That's not counting rewrites. And Judge Tipton made me a far better appellate judge, but it was arduous. It was completely arduous.
Were you traveling?
We traveled some. You know, Tennessee has a unique system in which the judge on the appellate bench gets to have a chambers in their home county. So I did not move my home to Knoxville. I remained in Johnson City, and I had a chambers in Johnson City. We traveled at that time. We sat, I think each judge sat 9 times a year. I think the court may have sat 10 or 11, but in any event, we probably traveled no more than 6 weeks a year, because at that time the Court of Criminal Appeals would interchange between Middle and West Tennessee, but still, if you're sitting 9 or 10 times a year, you're still in your home district, at least 3 of those, so you're probably only traveling about 6 or 7 times a year.
Did you find that your experience as a trial lawyer or a trial judge really make you more empathetic to the litigants who appeared before you?
More empathetic. I've thought about that. I don't really think that would be an emotion it would cause, or that it caused me personally. I think that you have to struggle as an appellate judge not to rethink what the trial court did. And I think that people who become appellate judges without ever being trial judges have an even more difficult situation, because they're more inclined to want to substitute their judgment. I think being a trial judge is a good prerequisite to being an appellate judge, because it clearly gives you a greater appreciation for the difficulty that the trial judge is in. I mean, like they like to say, the trial judge is, you know, calling balls and strikes as fast as you can throw them, and the appellate court's sitting there for a week wondering whether it was a ball or strike. So I think if you've been a trial judge and you go on the appellate bench, you have maybe a greater empathy for the trial judge and why they might make certain rulings that seem incorrect to you as an appellate judge. But I don't really think the litigants, that it created any great sympathy or empathy. I mean, I already have too much of that. I probably couldn't be any more sympathetic or empathetic than I am.
Sometimes does the fact that you really practice criminal defense law, did that make you perhaps less sympathetic to some of the
Yeah, I think it can
litigants?
have that effect, for sure.
Because?
Well, I mean, you know, the system is fallible, and I have many cases, at least more than a few, where the system failed, in that the defendant was wrongly accused. But I also have cases where the system failed because the defendant was wrongly acquitted. So.
Do you ever feel a sense of frustration in reading the record sometimes that maybe the lawyers didn't exert as much effort as that you wish they had?
That was a completely horrible experience. I remember just dramatically the first time I sat on a special workers' compensation panel. I was on the Court of Criminal Appeals, and at that time the Supreme Court was beginning to use other appellate judges and trial judges to sit on workers' comp panels to help reduce the workers' comp load. And the first set of workers' comp briefs I read were like A-plus papers in comparison to the briefs of individuals who had life sentences and 30 and 40 and 50-year sentences filed by maybe overly taxed or maybe just not appellate quality lawyers who were representing defendants on appeal. So the quality of the lawyering, both on the record, reading the testimony, and also in the briefs, could be something that can really frustrate you. It's even more complicated in the criminal setting because you have to worry about every convicted accused following up with a post-conviction case challenging their lawyer for ineffectiveness. So if you're on the trial bench, you're really frustrated if the lawyer is not providing effective assistance. But yeah, that can be a real difficult challenge to not want to suit up for the side that didn't put out their best effort for their client.
Other than Judge Tipton, who were your other benchmates on the Court of Criminal Appeals?
Just Judge Wade, now Chief Justice Gary Wade, when I was there. There were only 3 at that time. It became a 12-member court, 4-member district court in later years.
Do you have any good stories about your experience at the Court of Criminal Appeals that you could share with us?
Yeah, I will have to tell you a Judge Byers story. Now, he retired, but he continued to sit as senior judge. So the first time that I went to sit here in Knoxville, we were in the robing room. It was Tipton and Wade and Byers and me. And Justice Byers said he was there on my first day because he wanted me to make sure I understood the court's protocol. And he undertook to tell me that as the newest member of the court, that it would be my role, and then he starts to go down this laundry list of things, and they get more and more egregious. So he starts with, to come in the robing room first, and to make sure that the briefs have been delivered by the clerk's office, and to make sure that the coffee's out, and to make sure that the coffee cups have been filled for each judge, and to make sure that the hotel reservations have been made when we go to other places, and to make sure that the judge's luggage is removed from their car. So he goes on, and they're all 3 just not looking at, not even cracking a smile. And so finally he can't contain himself any longer, and that was a nice welcome to the court. But anything justice I do remember a case, a funny case, in which the defense was in the trial court that the defendant was entrapped to sell drugs to a woman because of the way she was dressed. She was dressed provocatively. And so she entrapped him to sell the drugs. And I had fun with that opinion, and Justice Wade wrote me a letter and made a nice comment about, I said something like, it would take more than a beautiful woman in a seductive costume to make the defense of entrapment. But it was cordial. It was very cordial. It was hard work, and Judge Tipton had high expectations, and Justice Wade had high expectations. But it was cordial, and I was really proud to serve with both of them. They both taught me a lot.
2 years after moving from the trial bench to the appellate bench, Governor McWhirter appointed you to serve as a member of the Tennessee Supreme Court. Tell us a story about how that happened.
We were at a judicial conference it was October, so my guess is would have been Fall Creek Falls. I had left the judicial conference to fly to Maine or Vermont, Maine I think, to teach. I had become very active in judicial education through the National Judicial College and would frequently go to other states to teach judicial education programs. And I had flown there at the end of our judicial conference, actually a little before ours was over, to teach for a three-state program up there. When I got there, I had 2 phone messages at the hotel. One was from then Judge Wade, and the other was from Justice Daughtry, then Judge Daughtry, because by then she was on the 6th Circuit Court of Appeals. Both of them said, "Call me immediately." As it turned out, right as I had flown out of Nashville to Maine, Justice Charles O'Brien had announced his resignation from the Tennessee Supreme Court to go and work on a political campaign. To everyone's complete shock and surprise, as I understand. I wasn't there, but as I understand, everyone was surprised. Both of those phone calls to me were inquiring, or perhaps prodding, whether I wanted to be or would be an applicant for Justice O'Brien's seat. As I recall, I reached Judge Daughtry first, and she was very encouraging. And at that time in our history, Judge Daughtry was the only woman who had served on the Tennessee Supreme Court. And when I went on the Court of Criminal Appeals, she had been the only woman on the appellate court, and when I went on the Court of Criminal Appeals, I was the second woman. So she had been a kind of a role model, although we had never served on the same court together. She had still been a kind of a role model, and Judge Daughtry is largely responsible for the tripling or quadrupling of the number of women judges in Tennessee, she and other women in Nashville, in and around Nashville. So she was encouraging. Judge Wade, I think, was exploring to see, to be the kind of gentleman that he is, the kind of diplomat and gentleman that he is. So within about 20...
Think he might have had some interest himself?
I'm sure he did. He was very qualified.
Yes.
And of course he knew Governor McWhorter and I didn't. And I don't like that old saying about how you become a judge, but I mean, we have to be honest about some things, about all things. So anyway, within about 24 hours I had decided, yeah, I'm gonna go for it. And honestly, unlike going from the trial to the Court of Criminal Appeals bench, I was open to a different kind of life than I was having on the Court of Criminal Appeals. And I realized I'd just been there 2 years, and I was getting better at it, and I did have a lot of other outlets of professional development as on that intermediate court. But the workload itself and the nature of the work itself was not my favorite. So I applied and went through the nominating process again, made the final 3 again. This time I did meet the governor. He interviewed each of the I understand he interviewed each of the candidates individually, and then he made a selection.
Do you remember who the 3 candidates were?
Justice Holder, myself, and Chancellor Richard Ladd from Sullivan County.
Do you recall now who your fellow justices were when you were appointed?
Absolutely. I sat with, when I started, it was, let's see, we changed twice, but Chief Justice Riley Anderson, and later, before I left, Chief Justice Adolfo Birch, Justice Frank Dwoda, and Justice Lyle Reed.
We talked a little bit about your transition from the trial bench to the Court of Criminal Appeals. What type of transition was it from the Court of Criminal Appeals to the Supreme Court?
In most regards, easier, although there were administrative differences, obviously. The court managed, directed many boards and commissions, so there was an administrative workload that was different. One that I had not had on the Court of Criminal Appeals. The caseload, the volume was drastically reduced, the Supreme Court being a court that takes cases generally based upon their discretionary decision to do so, not an automatic appeal. The deliberative process was was wonderful and much different in that the Court of Criminal Appeals, many lawyers submit their cases on brief, and so the cases are just distributed and an opinion's written and they're circulated through the mail and people decide whether to agree with them. But in the Supreme Court, every case is argued, and the deliberation is, the oral deliberation between the justices is more, I thought at the time, for my 2 experiences, it was more robust, more challenging, more exciting, more invigorating, all those sort of things. And then the learning curve was to remember that the court was not an error correction court. And Frank Drawota would probably like to have $1 for every time he reminded me of that Penny, we are not an error-correcting court. And I would come into the Rule 11 conferences. Those are the conferences on which the court's deciding whether to take cases, and I would say, but this is wrong, or this did this, or this judge did this wrong, or this whatever, and they would say, Penny, we are not an error-correcting court. So that was the learning curve, to remember that the Supreme Court had to be selective in the cases it took and should only take cases that were, policy-driven.
As a justice on the Supreme Court, what's the collective process for deciding that it's time for the law to evolve and to overrule or sharply diverge from previous precedents?
The collective process, that's a, I think, let me speak abstractly and then I'll tell you why I say it. I think that it is, in my experience, it was less deliberate than the question would imply. To say what is the collective process for deciding that it's time for the law to evolve suggests that it's deliberate, that the court sits around and says, we got a problem with tort law, we need to take it in a new direction, or we've got a problem with this, we need to take it in a new direction. That may happen. It may have happened in Tennessee, but in the short time I was there, that was not at work. I came after comparative fault began. But I do think that how the law evolves and how precedent is changed is a function of having a collaboration of opinion, or having people of different backgrounds, of different experience levels, of different practice backgrounds and different personal backgrounds, who hear about a problem and a light bulb goes off, and maybe it's not a collective decision, but someone says, why is it this way? Or, well, when I did this, we did it this way. And so then the wheels start spinning and people start talking about whether the way we've always done it is correct. And I think that's why diversity on a bench is so important. And I don't just mean, the obvious kinds of diversity, gender, ethnic, cultural diversity, all kinds of age diversity, all kinds of diversity is so important, because that's what spins those wheels differently. I had two cases that I think, if people had such a limited period of Supreme Court jurisprudence to my name, but while there, I did have two cases that were fairly significant, that if you looked at, you might say, the law evolved here, okay? So one was Mcclung v. Delta Square, which involved liability for the acts of third parties, acts of violence of third parties against victims in commercial parking lots, to be specific. And then Sprint versus Megan, which was a class action case in an eminent domain context. So in both of those two decisions changed the law from what it had been before those decisions. But either by virtue of some questions asked in oral argument or our initial deliberations, and then the opinion was randomly assigned to me, then I do my research and I start looking at it and I start seeing what other states have done and I start thinking about it and I propose a written opinion. In both of those cases, I do not have any, I would have a recollection if it happened, so I shouldn't say I don't have a recollection. What I would say is that there was no collective process of deciding the law's going to change. We may have all been individually thinking that at one time, but I think what prompted the discussion of the law changing was the draft. So in my experience, there was not an orderly, deliberative, okay, here we've got a problem with the law, let's move here, or let's move there. It seems, I have students who work in the Supreme Court now, and so as a result, I'm able to, I force myself to keep up with what they're doing, and it does seem like the sophistication level of our state Supreme Court, and I don't know if sophistication is the word I mean, but I think it is different than when I was there. So maybe there is someone who you will interview who can answer that question more directly. But in my experience, it didn't happen.
Give us a little glimpse behind the curtain without revealing things that you're not
Sure.
supposed to reveal. You know, in today's society, people just don't seem to want to hear ideas that aren't their own. When you're in conference with your fellow justices, how did that go? Were you open to sharing ideas that weren't your own?
Yeah, boy, that was the intimidating part from the beginning. I'll have to say, Chief Justice Anderson was chief when I started, and he almost without exception started discussions with me. I mean, not only did he make it clear that I had a 1/5 and equal voice, but he made it clear to me that I better be prepared to defend the position I took, because I was not going to be able to latch on to what someone else said. So I found my experience to be collegial, to be respectful, without always being in agreement. I have said publicly, and I don't think there's anything wrong with saying this, the court had been divided a bit before I came. At least the rumors were that it had been divided, and I felt that we were clicking as a fivesome. I did some things that some women would have found inappropriate. I like to tease my 4 fellow justices about their ties. I like to break the ice in our deliberation meetings before we started talking. So I had a tie contest, and I can tell you for the record, Frank Drawota never won. His ties were just not. Nobody's ties would compare to Justice Birch's, but in any event, I did things like that. So I felt like we had kind of a good interaction. So behind the curtain, I guess I would say it really depends upon the individual members of the court. You only have to look north in the country to what's going on in the Wisconsin Supreme Court to know that not all multi-member courts function in this capacity. I mean, they are at the point now where they have to have their meetings recorded and viewed because of the animosity between different members of the court, and different members of the court have sued one another and so forth. So it depends upon the members of the court, and it depends on the Chief Justice and what kind of a tone and tenor the Chief Justice sets.
And who was the Chief Justice during the period of time when you were there?
First off, Anderson, and then Chief Justice Anderson, and then Justice Birch. And you know, one of the regrets in my life, I've got a few, but one of the ones, I have this wonderful recording, I can say it. You know, I had been selected as chief to follow Justice Birch. We had made that decision, the court had made the decision to decide in advance so that we would avoid the potential problem that might happen if there was kind of a competitiveness for Chief Justice. So Chief Justice Birch became Chief Justice, and I would have become Chief Justice in November of '96. And that to me, certainly it could be written up as my turn. It had just become my turn. But it meant a lot to me in the spring of '96, which was less than 18 months after I'd got there, that my colleagues had seen enough of my work and me as a person that they were willing at that point to go ahead and vote for me as Chief Justice. Obviously that never happened, and we got a female Chief Justice like 10, 11, 12 years later. But that is one great regret, that I did not get to fill that role.
Today, the Supreme Court justices frequently meet by teleconference.
Oof.
When you were on the court, did you teleconference or did you meet in person?
Drove to Nashville. I drove to Nashville. Everyone drove to Nashville. And yes, that's cumbersome, but boy, I think I don't know. I don't want to judge a process I've never been a part of, but I certainly felt that if I were talking about something that was important for me to get my point across, it was beneficial to be in the same room. You know, we also had a rule at that time, and I think many courts have this rule, that we only talked when we were all together. So that we did not, if we were if we were in our offices and we had a problem with an opinion, we might write a note, or today write an email or something, but everyone would have a copy of that. So I would not go to one judge's chambers and try to get that judge to agree with me on an opinion when the other 3 members weren't there able to hear our discussion and participate in it. So I also think that's another rule that leads to a more fair and collegial body.
How about your relationship with the rest of the bar as you moved up the ladder on the judicial bench? Did you find that your relationship with lawyers changed?
Well, I mean, it's a sad commentary on human nature, but I mean, you're everybody's favorite, and then when you fall, whew. But no, I mean, my relationship changed in that people were kinder, I guess, nicer. I was always a desired speaker. Come to our organization, do this. You know, I guess I didn't sense it at the time. I mean, I said that the court had a number of boards and commissions, and I was involved in some of the most active boards and commissions. So on these boards and commissions were lawyers from all over the state. And, you know, I just assumed I was forming lifelong relationships with all those people who were on those boards and commissions. But, yeah, I mean, it changes. People should respect the members of the court. But one of the things that I you know, struggle with is the people who change their impression of you just when your title changes. I don't find that a very endearing quality in a person, to treat someone differently when they can no longer help them get somewhere.
Right. Did you perceive any sense of isolation from members of the bar because you were separate and on the bench? Yeah,
I think that there is isolation. I was so busy, I never really felt it. If we weren't, you know, in conference or hearing cases, then because so many things happen in Nashville, all of the boards and commissions meet in Nashville, all the activity in Nashville. I was traveling to Nashville a lot. I was living in Nashville some of the time. I was living in Tri-City some of the time. So I didn't feel that sense of isolation, but let's also keep in mind it was a short period of time. I'm sure that judges who sit for 15, 20, 30 years really, really do miss the interaction that they could have with members of the bar.
Well, it was a short period of time, but would you say that before State versus Odom, you enjoyed your time on the Supreme Court?
It was a wonderful experience. It's hard to say whether I would do it again knowing what the outcome was going to be, but I think I probably would. It's such a wonderful opportunity to get to really think deeply about the law and to have an impact on the law in more than, you know, an individual case. And just the decision making with 4 other people is a challenge and an opportunity. I mean, because you can make better decisions with 4 other people than you can make on your own if you all take the time to share one another's points of view. You can grow from that and make a far better decision than you could make individually. It's harder, but it's in the long run, it's just a much richer decision.
We're going to talk about State versus Odom for a little while, but before we do that, why don't we take a short break so we can make some technical adjustments, and then we'll come back and talk about it.
Thank you.